Welcome. This is a Stepping Stone series. Pete Carter, Land Grab, interview by Caroline Stevens. Over to you, Caroline.
Welcome to a Stepping Stones interview. I'm Caroline Stevens. Today I'm welcoming Pete Carter. He's based in Derbyshire. Hello, Pete. You've got a very interesting company name. Now, is it Tunkashila or Tunkishila? Can you explain what it's all about and your story about the law and the land grab? Over to you, Pete.
A little bit of background first on myself. I was project manager back in 2010 and 11. I had two companies as well in the IT business, but I was a project manager for telecoms and engineering. I left that due to a family issue where I first had experience of Her Majesty's Courts and Tribunal Services. Are we okay? I've lost sound, I think. Have you?
You're fine.
You're all right, yeah. So yeah, that gave me the first experience of the court system, and then after that, there was other issues. Basically, I ended up having to take the Secretary of State for Work and Pension to court over unlawful deductions for child support agency, where I had a shared residence order for my child, but the Secretary of State had classified me as a absent father and a non-resident parent, and had been deducting unlawfully large sums by way of a deductions of earnings order, where there was no hearing or anything like that. It was just basically faxed over to my employer arbitrarily, you might say, which led me to a sort of 2.5 year battle in courts in Manchester, then into the High Courts, and then over into the Royal Courts of Justice, where the state basically cheat and and all kinds of
Pete,
we could go into all
can you
kinds.
just explain when you say it's been passed from court to court?
Yeah.
Was it a case of they stipulated how much you had to pay, but you had a dispute over the physical amount?
No, absolutely not. So basically, I had a shared residence order. Back then, they were called shared residence orders under the Children's Act of 1989. A shared residence order was an order settling the arrangements of where a child is to live. So clearly, the child lived with me for half of a week, basically,
Yeah.
and he lived with mum in a different household for half of a week. Now, the issue became about because although the Child Support Act 91 recognised that there could be two persons with care, the Secretary of State for Work and Pension and the Child Support Agency did not recognise that there could be two persons with care, and automatically assumed that one parent must be what they called an absent parent or a non-resident parent. Basically, like I say, that their decision to classify me as a non-resident parent or absent parent was arbitrarily made. There was no notices served. There was no court hearing. There was no tribunal hearing. They simply received instructions from my ex-partner and the child's mother to proceed with a case against me. And what they did was simply just fax over to my employer basically a very loose piece of paper that basically gave an amount that they wished to collect from my wages. And my employer started deducting at source without any court or tribunal hearing at all.
Wow.
Large sums of money from my earnings. So at one point, well, for a considerable period of time,
Yeah.
I was working 60 hours a week, and I was coming home with a net pay of £454.54. And yeah, it was absolutely shocking, to be honest. But ultimately, like I say, it was a 3 year battle at court, Manchester court, then into the High Court. There was a very nice judge at Manchester High Court eventually, called His Honour Judge Armitage QC, and he's retired now. But he gave me that opportunity to appeal it based on the human rights violations that I was arguing from the beginning. Which was successful. Their barrister, the Secretary of State, sent a barrister from Landmark Chambers, and it was a female lady, and she couldn't even address His Honour Judge Armitage QC that particular day. She asked him if she could remain sat down because she literally couldn't stand to address him, following my half a day legal arguments, basically. I'd obviously spent a considerable amount of time on the legal arguments.
Presumably, you spent a lot of money as well.
Well, I did everything myself. I had to learn it all myself. Particularly, didn't spend a lot of money apart from time and energy and resources. I did initially have solicitors acting for me, but then I ended up sacking the solicitors because it was quickly apparent that they were taking, again, large amounts of money out of what I was earning and providing very little by the way of they were just dragging it out, basically.
Yeah.
Dragging it out and taking their time. And obviously, I was on a payment plan, monthly payment plan with them. So, for a whole year, basically nothing really happened. So in the end, I just decided to go alone and do it myself, basically. So. Interestingly, though, I technically lost that case on paper. I shouldn't have lost that case on paper. In fact, the Secretary of State had no rebuttal or argument to any of the legal points and submissions that I made. And the court in Manchester High Court reserved judgment. 3 and 4 months later, I was still chasing up where the judgment was. And then His Honour Judge Armitage QC, before he retired, wrote to me, basically sent me a draft judgment advising me that for some unknown reason, somebody had been into his private chambers at the court and removed large parts of my bundle of evidence. And when he made the judgment, basically 3.5 months later, after the hearing that I just mentioned, parts of my bundle were missing, and he basically wrote it into the judgment that he made the judgment on the basis of what he had available to him, caveated by the fact that large parts of the bundle had disappeared and the claimant's evidence had disappeared.
But that's shocking, isn't it? I mean, that's theft of evidence and negligence.
It's negligence, it's theft. Obviously, nobody could give me a straight answer. Apparently, the only types of people that have access to a judge's chambers behind a court, obviously, the public certainly don't have access to them because they're coded doors everywhere. Would be people in the HMCTS and higher echelons of government.
Yeah.
It then went to an appeal to the Royal Courts of Justice, which was completely shocking. It was sent 3 times to the Royal Courts of Justice by way of special delivery, grey bags. Each time was signed for. Each time they were weighed with obviously the weight of the bundle that was in them. And in a nutshell, there was arguments with Civil Appeals Registry Office at the Royal Courts of Justice where they turn around and say, well, yeah, we've received something from you. We've got, we'll admit that we've signed for something, but we say it was a letter. It was only a cover letter that you sent. You haven't sent an appellant bundle to us. And you say, well, I clearly did. It was weighted. I tell you what, we'll send it again. So you'll send it again at the cost of £12 something by special delivery, Royal Mail, guaranteed before 1 next day.
Yeah.
They'll say they'll sign for it again. You'll get the proof that they've signed for it again, but then they'll argue with you that actually there's no appellant bundle here for the second time. So in the end, I had to photograph the bundle going into the grey bag with the postmistress in Warrington, in Cheshire. And, the postmistress couldn't believe, what was happening. And I actually sent the photographs to the Civil Registry Appeals Office on email. And the lady that we were corresponding with at the time, I basically threatened her with perversion of the courts of justice and that I'd have to privately prosecute her if this disappeared again,
Yeah.
On that third time, they did accept it. They did put it through. But then what happened when I got to the hearing was the judge turned around and said, well, you're out of time. You've only got 14 days and you're outside the time window. So, blah, blah, blah. So that's my experience of the justice system. I've got many other stories about the justice system in terms of other cases that I took against Greater Manchester Police and all kinds of other stuff in the past. But, in relation to what you're asking me about Tuncarshula.
Yep.
And
love and respect for the land.
Love and respect for the land, yeah. Now, Tuncarshula was the name I decided to call the company that I set up. I set the company up in December of 2016 for the sole purpose of purchasing a legal estate or land over in Glossop in Derbyshire. The background to that event basically was in the month of November, I met a lady who had been evicted from her home previously by High Court Enforcement Group Limited. High Court Enforcement Group Limited, private company, who are acting under license and authority from the Ministry of Justice and the Lord Chief Justice of the country to basically evict people from their homes and enforce High Court orders.
Now, when you say evict people from their homes, there'll be a lot of people at home now thinking, what do you mean by evicting people from their homes? Are we talking about tenancy arrangements? Are we talking about mortgage situations? People who've got freehold, they own the house?
So the usual kind of evictions that High Court Enforcement Group will carry out is your classic example where you've missed 3 payments on a mortgage. The lender, the bank, the mortgage provider has taken that person through a very quick process in what they call possession claim online, PCOL. And basically, once you've missed 3 payments, they'll put you through the PCOL system, which is an accelerated fast track process. The mortgagor, the mortgagee, the bank, is always going to get an order for possession, and that's how the system works. There's not really any argument that you can run in a county statutory court during that PCOL process which would avoid a possession order being granted, unless you make an offer to clear the arrears and pay the outstanding amount.
So you've got a case. So basically, we're talking about cases where people have mortgages with the bank or the building society, and after 3 months of non-payment of their mortgage,
then the bank can go in and, well, in fact, legally, the bank can actually repossess a property on day 1 of a mortgage deed. If someone's purchased a property with a mortgage from a bank, legally and technically, the bank is also a legal proprietor of the charge, and therefore they have absolute right of possession and legally could actually take possession on day 1 without any arrears. But obviously, that would be very controversial for them to do so. So it tends to be the fact that they would only take possession, obviously, if you fall behind on arrears and if that bank has decided to take action to try and enforce its charge. So that's your usual. This particular lady that we're talking about in Glossop in Derbyshire, a lady called Rekha Patel, she was actually evicted from her own property, which she paid for in full. So initially, when she purchased the property, she had spent, I think it was £167,000 on the property. The property was in a vacant, derelict state. It had been derelict for some time. It needed remedial work and obviously substantial amount of work doing to it.
Now, Pete, if I remember rightly, this is a semi-detached property, isn't it? So it's attached to somebody else's property.
There's actually 2 properties that it's attached to. It's
right.
It's a middle. I think you'd call it a middle terrace cottage. With neighbours either side.
Yeah. Okay. It's quite relevant, isn't it? Because for the outcome, I think.
Sure, yeah, exactly, yeah. So there's a neighbour on the left-hand side, and there's also a neighbour on the right-hand side. The neighbour on the left-hand side's got quite a small property, and the neighbour on the right-hand side has got a very large property with a lot of land. Now,
so this is a case where there's no bank or building society involved in this. She owns it outright, and her name presumably appears on the land registry.
It would have done until we purchased the property from the people that we purchased the property from. So if I can, I'll briefly explain her position, okay?
Yeah.
Before I go on. So obviously, I didn't know the lady at all till much after she'd been evicted from an unfortunate situation that occurred in relation to her and a neighbour, okay? The neighbour who lives next door to the right-hand side took a claim against Rekha Patel for what she alleged was damage to architectural feature stones called thack stones that were damaged from her builders that was doing work on Rekha's property and Rekha's roof line. Okay.
Right.
And essentially what happened there was the neighbour next door said, look, I've got these architectural feature stones that protrude out from the gable end of my property. Your builder has cut through them, and I'm, now going to take a claim for for damages as a result of that. Okay.
Okay.
Now, at the time, Rekha obviously was quite horrified by what she was, thinking. She immediately had the work stopped. She complied with because this is a Grade 2 listed building. They obviously the neighbour sent around a conservation officer and the council people in relation to the fact that it's a Grade listed building, and perhaps she or a builder was alleged to have caused damage to stones. So she was complying with them. It turned out that actually the neighbour knew the conservation officer from the council, and basically they developed and hatched a plan to basically financially ruin Rekha Patel. Personally, having looked at this, I believe it's now, I didn't believe it at the time, but I do believe that it's now a racially motivated attack. They simply didn't want her living in the area, basically, from what I can gather, because the original story of the stones and whatever, it went to court in 2013 in the small claims court. The neighbour next door got a successful judgment in her favour, leaving basically the judgment was that Rekha Patel would pay £8,318.88 plus costs summarily assessed at £2,500. Now, Rekha obviously wasn't happy with that. She tried to appeal it in Manchester. She was flatly refused and given incorrect advice by the judge, Judge Recorder Freeman at the time. And Recorder Freeman actually advised her that she was not entitled to appeal in the High Court at Manchester, and that she must go to London, which was incorrect. But nevertheless, obviously Rekha and the bad legal advice she'd had went to the Royal Courts of Justice in London to appeal the matter. At this time, Rekha has now been in contact with the person that sold the next door neighbour's house to the current person who had actually taken this claim against Rekha. He was a retired steeplejack builder with over 40 years experience in the building industry, working on Grade 2 listed and other listed kind of buildings in and around the Derbyshire High Peak area.
So where does this chap come into this? He bought one of the other houses?
No, he was the person that sold the next door neighbour the property in question, which she alleged the stones protruded from. Yeah.
Right.
So he basically turned around to Rekha and said, "Look, I've already had a visit from the lady who took you to court. Her name's Frances Briley. Yeah. I had a visit from Frances, and I'm going to tell you what I told her. There was never any stones protruding from the gable end of that property. He had all this English heritage information. He wrote a very well put together statement.
Oh, that's interesting then, isn't it?
Very interesting. And then it went to the London Royal Courts of Justice, where he was willing to testify on oath and evidence of the fact that he sold that property and that these stones never actually existed at all. And it was basically a fraudulent claim from the beginning.
Okay. Oh, gosh.
Obviously, the neighbour next door had a very comprehensive, what they call third-party litigation insurance. Now, third-party litigation insurance is what we'll call an emerging market. Since sort of 2014 on onwards, has been a very, very emerging, lucrative industry and market. Because of the cuts to legal aid, basically there is now private equity hedge funders and third-party litigation insurance companies that are willing to fund claims either on an individual basis or on what they call a grouped portfolio basis. Okay.
Yeah.
Now, this Frances Clare Briley had a very comprehensive package with, initially, against Rekha, it was a company called Duke Street Private Equity Hedge Funders. And after that...
are these like angels then, or are they...
Angels?
Yes.
How do you mean, sorry?
No, I'm just thinking they call them angels when they go into businesses. It's not like that, is it? It's just people out to make money.
Absolutely out to make money, yeah. And common law used to forbid what's called champity and maintenance.
Sorry, what on maintenance?
Champity and maintenance.
Right. Okay.
Basically, if you were funding somebody else's litigation and you were seen to have control of that litigation, and therefore common law expressly sort of forbid that kind of activity because it could lead to all kinds of unfavourable situations where the funder of that litigation is basically simply taking action to get what they call a return of the spoils.
Right, I get you.
Yeah. But now, with the fact that legal aid has pretty much all but disappeared, it has basically come back and they've abolished the common law rules by repealing it with statutory instrument that repeals all of that stuff and then obviously makes it okay, So there is a huge industry in third-party litigation funding. It's several hundreds of billions and still climbing year on year. There's quite a lengthy amount of information online about it. If you look at Harbour litigation funding and other reports that are in the public domain, you'll see just how lucrative that third-party litigation funding industry is.
So this is a growing industry.
Oh, it's a hugely growing industry because you can get a return on investment far bigger than any stocks, shares, bonds, or bank accounts can ever provide you with.
Yeah.
So it's 2,000% return on investment as opposed to your average 8%, 6 to 8% in a high interest savings account.
Yeah.
Yeah. So that's that industry. Mentioned. Obviously, at this point, so she appeals it to the Royal Courts of Justice. Obviously, she's got structural surveyors, RICS qualified surveyors, expert witnesses, along with this previous owner of the property that actually sold the property to Francis Briley. They trundled down to the Royal Courts of Justice for an appeal, for permission to appeal. All gets aired, and essentially the court said, look, we don't understand why this evidence wasn't available to you, Rekha, when you originally had the court trial. And the bottom line to that argument is that she simply wasn't aware of Graham and the person that sold this house, and she simply didn't have the information that. And she trusted the council and the conservation officer and all of these people who were telling her, look, your builders have damaged the property. So in hindsight,
these are supposed to be the experts. They're supposed to be working with you, not against you.
Well, yeah, but unfortunately not in this particular case. So she wrongly or naively trusted that the conservation officer was legitimate and genuine, and the people were obviously legitimate and genuine. Upshot was that the Royal Courts of Justice basically turned around and said, look, we can't allow this appeal to go forward. We're not going to give you permission to appeal. We're going to strike out the claim as wholly without merit, and that it has no merit at all. We think there's something untoward with the fact that this evidence has only just come out, and that's the end of it. You're simply trying to run the litigation and have a second bite of the cherry on this litigation, and it would be wholly unfair for the person who's already had a judgment in her favour to have to go through basically a second trial on all of the facts. Yeah.
So basically, this has gone against Rekha then.
So that went against Rekha, yeah. So that was 2014. Okay.
That doesn't seem fair, does it? That fact that these experts were not helpful.
Well, at the end of the day, you can see argument in both sides that, that there was a claim that was made. The claim was obviously heard at a trial. And then obviously after that point, new evidence has come to light that actually these stones didn't exist. I think the court feared, in my opinion, that had they given permission to appeal, there was absolutely no rebuttal that the neighbour who originally brought the claim could have actually provided to the evidence that was on the table,
Yeah.
Because it was that overwhelmingly strong. So in that, they basically turned around and said, look, we're going to just say no to the appeal. You're not having a second run of the litigation. It'd be unfair to this person to do so. Obviously unfair to the litigation insurance companies that were also funding all of that stuff. And basically said, look, you have to pay this amount of money. It's the original judgment stands £8,318.88. Plus now the costs have gone up. The costs were originally £2,500, but now they are summarily assessed at £8,500. So as a result of the fact that she went to the Royal Courts of Justice to do the appeal stage, yeah.
Yep.
So that was just short of £17,000. Now, when I first met Rekha, I was under the impression that she had not paid that amount of money. And when I first met her, having seen that she'd been evicted, I assumed that she simply couldn't afford to have paid the £17,500 and that the neighbour had took the property in order to try and realise that £17,500 and, that's why she'd been evicted. It transpired actually that she did pay Frances Briley. She paid just short of £17,000, which was in line with the Royal Courts of Justice order. She paid it in the March or April of 2014, and I've personally seen the Halifax cheque stubs and the Halifax bank statements showing the debit basically coming out of the account to Frances's lawyers at the time, which was Cogent Law. Okay.
This is the lady next door who still lives there, I assume.
She does still live there, yeah.
Yeah.
So she was paid. She was paid in full. At the point that it was paid, obviously, because it was cost summarily assessed, that means that if you pay cost summarily assessed, that the matter is disposed of, and that Rekha Patel at the time she paid was no longer to be considered as what they call a judgment debtor, because payment had been paid to the judgment creditor.
So everything was settled, allegedly?
Everything was settled allegedly March or April 2014, correct? Yeah.
Yeah.
And then Rekha obviously noticed that there was still charging orders on her property following the fact that she had settled the matter. Yeah.
Yeah. Which would mean that she couldn't sell the property.
Yeah, or she did try and sell the property. Obviously, then a conveyancer would likely try and remove costs that were on there that obviously had already been paid.
Right. Okay.
So she applied back to the Manchester court, and she was successful in getting an order for the entries that were on that title register to be vacated forthwith, which means basically removed forthwith, immediately. Yeah.
Yeah.
Okay. So that happened. Unfortunately, the lawyers at Cogent Law didn't. It was their responsibility, and the judge said it was their responsibility to send that into the land registry because they were the person holding that charge. They had to discharge it from the land registry and send it in. Unfortunately, they didn't do that, and they left the charges on the property. And then several months after this event, they sent a threatening letter on letterhead. The court matters were done and dusted. They sent a threatening letter on Cogent Law letterheaded paper saying that they'd actually reviewed. They'd had their costs looked at by a cost draftsman, they called it, where they now believed that Rekha needed to submit £29,000 to their sort code and account number on the letter within, I think it was 14 or 21 days, or risk the consequences of going back to court. So this was a matter that had already been going on in court for 4 years. A matter that Rekha believed she'd completely settled by paying the £17,500 after losing in the Royal Courts of Justice and thinking she had no other option but to pay it. And then obviously out of the blue a letter comes through saying that you actually owe us £29,000 deposit in this sort code and account number. Obviously Rekha ignored it.
And this is from is this from the solicitors or is this from
the solicitors for the neighbour? Yeah.
For the neighbour, okay.
Cogent Law, yeah, not Rekha's solicitors. This is from the neighbour's solicitors, yeah. So the matter had already been dealt with, settled as far as Rekha was concerned. But then the neighbour's solicitors, several months after the event, decided that they were going to send a threatening letter to Rekha for sums of 29,000 and something pence. Basically deposit it in this sort code and bank account number, which was written on the letterhead. By particular date by 4 p.m. If you don't, we'll take you back to court. Was the attitude of the letter? Yeah.
Yeah.
So Rekha just saw it as extortion, just as a way of trying to extort money from her, and just basically ignored it, knowing that she wasn't a judgment creditor. And she'd also applied to the Registry Trust Limited. Now, Registry Trust Limited are the registrar for all HMCTS county court judgments, fines, forfeitures, collection orders, that kind of thing, So any judgments or whatever that the court make, they are all submitted onto the Registry Trust Limited database, which is accessible online. And if you pay I think it's a small fee of £8 or £12, you can basically get a copy of whatever judgments and fines or forfeitures have been ordered against a particular person or a particular address. Okay.
Right.
Rekha applied for a copy of her own file from them, which showed that she was not a judgment debtor any longer, and that everything had been satisfied and removed from that register. Yeah.
Yep.
So she ignored the letter. Basically, what happened was a
Should she have
barrister.
responded, by the way? Can I ask, should she have written back and said that she wasn't aware that she should have paid any more money?
Do you know what? I can't answer for Rekha whether she did reply to the letter. I'm saying she ignored it. What I mean by that is she ignored it, and she didn't obviously. She didn't give in to the demand of £29,000. Yeah.
Okay.
I couldn't tell you actually whether or not Rekha responded to that letter directly to the to the neighbours' legal team or not. That's something we'd have to ask Rekha, to be fair.
Okay.
I can take an action to find that out.
Yeah.
But yeah, I mean, either way, as far as Rekha was concerned, and the paperwork that I've definitely had in my possession, the matter was concluded and it was settled, and there was no real grounds for them to go back for this alleged 29,000, because the time to do so was, if they wanted a detailed cost assessment with a cost draftsman and all that kind of stuff, the time to do so is the minute that the court is giving summarily assessed costs. They then make an application and say, look, your summarily assessed costs at 8,500 are way out of line. We've got costs of the region of, I don't know, 29,000. So actually, we now need a cost judge to look at a detailed cost assessment of this. That's the way it should be done. They can't clearly come back to it many months after the event and start basically taking the piss, which is...
So basically, so if we fast forward to now, she's now, so to sum up, she's now out of her own property.
Yeah.
Of which she's paid, was it 170,000 originally?
170,000 plus there was a lot of work to be done on it, building work equity, sweat equity. You're probably talking another 40 or 50,000 that went into the property and the renovations that needed to take place as well. So you're talking a rough figure of 210 in total.
So basically, she's paid all this money, and now she has no property because she's been evicted from her property.
Yeah, she was evicted in 2016 from the property. It did hit the mainstream news, Manchester Evening News, and other things, which, funnily enough, is how we come to know about it some months after the eviction, when I was shown the very aggressive and hostile. Excessive force, in my opinion, by people that were acting as High Court enforcement agents through High Court Enforcement Group Limited. Yeah.
So basically, now who owns that property?
So my company has owned that property since December 2016. It was legally and lawfully purchased from two companies. I don't know if you're aware of the headline that hit the Daily Mail, and also it went international, but Rekha decided to sell her property to two companies for £2. She sold it to a company called Land and Property Protection Alliance Limited and a company called Fringed Limited for basically £1 to each company. That hit the news, I think, last year. Now, I then came in after that, and I purchased it from them two companies for basically £100 plus other valuable consideration, namely the fact that she was a sitting tenant. So I had to honour the original tenancy of 10 years, which expires in 2026, which was legally assigned by a deed. So it's a tenancy assigned over from the two previous landlords, Land and Property Protection Alliance Limited and Fringe Limited, which was all done by lawyers, regulated SRA lawyers. It was a commercial transaction, and it was all done legally and lawfully, and obviously was submitted to the land registry for registration.
So this is now in your name. You were the landlord.
Yeah.
Rekha was your tenant.
Yeah.
And now
Rekha was paying me a rental on that as well. Yeah.
So then what happened? She's now been evicted.
So she was evicted the first time. Obviously, the sale went through. At the time the sale went through, she was actually back in possession of the property and a sitting tenant. And then what happened was Francis Briley took a claim against both Rekha and myself as a second defendant. Myself as the company that owned the estate, the registered proprietor. Yeah.
And she was supported by the police, wasn't she?
She was absolutely supported by the police, yeah. She's been supported by Derbyshire Constabulary throughout this entire event. To give you an example, every time I've been at the property with official copies of land registry title deeds, I've been arrested by Derbyshire Constabulary. I was arrested back in August. I was held for 9.5 hours the first time, and then I was released without charge pending an investigation. That investigation by Derbyshire Constabulary concluded within 3 weeks, and I received a letter from a PC Mark DC from Derbyshire Constabulary telling me that no further action would be taken against me or my company, that they had clearly obtained the Her Majesty's Land Registry deeds from HM Land Registry on the 4th of September, that they were satisfied that I was the conclusive and registered proprietor of the estate, and therefore no further action would be taken.
Well, Pete, it's quite amazing, isn't it, when we have so many crimes stacking up now, the police won't come and investigate, you're given a crime number, and then those crime numbers are often rescinded, and you've got a situation where a lady is living in her own property and everything is being done legally and lawfully in your side, and the police seem to have this heavy-handed way of getting involved in effectively civil disputes.
A civil matter. Yeah, it's a civil matter, exactly. And one thing we've always said to the constabulary, and obviously they've been on notice for some time. When we say they've been on notice, obviously in August of last year, following my first arrest, Derbyshire Constabulary was served notice that went out to Peter Goodman, who's the Chief Constable. It went out to Deputy Chief Constable Hopkins, and it went out to Craig Sutherland, who's the Force Legal Services Department, head of Legal Services Department, and it also went over to Professional Standards Branch as well within the Force, for them to basically have a legal notice and be advised of what the situation was, and that it was our position that Derbyshire Constabulary were committing the offence of aggravated trespass against us as the company, because they were interfering, as we saw it, they were obstructing and interfering with the lawful business activities of my company. Yeah.
But the interesting thing, Pete, is we haven't actually mentioned the fact that you've been studying law alongside these events, and you're just graduating, so you know exactly the way the law, should work, yes, and how it's not working at all. So anybody watching this program today must be thinking, what is the point of having these courts? These courts are all private corporations. We've got police who are presumably, who's paying them to look after the public?
This is an interesting question, because there's clearly, for want of a better expression, in my opinion, brown envelopes being passed around in this particular case.
Do you feel though, Pete, that this is happening in more and more situations? I mean,
absolutely. I believe that this lady back in 2016, when she was evicted, obviously. It shocked me in a way, because I've seen many evictions, I've seen many very aggressive evictions, I've seen armies of police facilitating and aiding evictions, but them evictions have always usually been where there's a mortgage and the banks are heavily involved and the banks want to get their capital back and all that business. I mean, there's also arguments there that the banks never actually lend any funds, and that you are the sole creditor when you sign the promissory note. But to step aside from that for a second, as well as the Lord Adair Turner, basically is famously quoted from saying that basically banks don't actually lend anything at all. Lord Adair Turner was, I think, the either finance minister or ex Bank of England governor. But anyway, you can see it online. Lord Adair Turner basically said that banks don't actually lend anything at all in relation to these mortgages. That is simply an extension of credit, and an extension of credit being that they simply create the funds digitally out of thin air, with say a few strokes of a pen or a few clicks on a keyboard, and all of a sudden there's this loan account. With this amount of credit.
Well, of course, I mean, the banks can lend 90 times their deposits, can't they? Or even more, depending.
Yeah, so yeah, that's how the quantitative easing sort of system
That's right.
works.
So,
Yeah.
so now,
Yeah.
how will you proceed now on this case? Reka has now left the property. You're no longer involved in the property. Have you got any court cases pending against you?
So when you say we're no longer involved in the property, we were the registered proprietor. And recently, this week, basically, we have now discovered that HM Land Registry have fraudulently acted against us. So what we mean by that is we need to be very clear on what we're saying. Is because our company legally and lawfully purchased the estate, and obviously we were conclusive owner.
Yeah.
Basically, the state guaranteed to us title absolute with full title guarantee. Yeah.
Yeah.
Nobody nobody at all has a better right to that estate than obviously the company did have. Yeah.
Yeah.
Our lawyers at the time, when they put that transaction through in 2016, also put what they call an anti-fraud restriction on the title. And an anti-fraud restriction is supposed to protect the registered proprietor and the conclusive owner from any attempts of fraud being taken against it. So at the moment, property fraud and land fraud is a huge industry where the law appears to be favouring the perpetrator of the fraud, the actual fraudster, than it does the victim of the fraud. Now, this was never the case with unregistered land. It was never the case with unregistered land because common law would not allow a fraudulent transaction to stand up against a victim. It would always set aside that fraudulent transaction and not allow somebody to gain from something that was fraudulent. Unfortunately, with the way that the registered land regime or system is set up, that is not the case at all. In fact, the law favours the fraudster that commits that fraud and receives title in that name.
Pete, can I just interrupt you?
Yeah.
Do you see that with the advent of digitised land registry,
Yes.
what potential problems will perhaps our viewers have?
Huge ramifications, because we already, in our particular case, we already have evidence, hard evidence, in our possession that one assistant chief land registrar by the name of Chris Day from the Welsh office, and the Welsh office has absolutely nothing to do with my title. My title was managed out of the Nottingham HM Land Registry office, and it says that on my title, that it's to be dealt with exclusively by HM Land Registry Nottingham. So why a Mr. Chris Day from the Welsh Land Registry office as an assistant chief land registrar has been getting involved in my title and deleting, basically he deleted the 10-year tenancy that was registered on there between me and my tenant, which was a deed. It was protected by way of an agreed notice between the two parties. It was on there, which clearly showed that the expiration of that tenancy was 2026. The deed was obviously lodged at the time we registered, because they have to have proof. You can't just put a notice on there and say, well, we've got this tenancy till 2026. You have to actually evidence it by showing the deed that was actually executed, and obviously that had to be certified by lawyers to say it was an original, genuine copy of the original deed that was executed, etc. Obviously all that was put onto the register, and then Chris Day came along about 3 or 4 weeks ago and simply removed that tenancy without notice, without a hearing. It didn't go to the property chamber, it didn't go to the lower chamber, the tribunal, the upper chamber tribunal. It didn't go anywhere. He just simply went onto the system, deleted the tenancy. In my opinion, he knew deliberately that that this fraudulent sale that's just took place this week couldn't have gone through whilst that tenancy was on there. So he actually removed it to help the fraudster get the sale through.
Wow. So basically, the police are in cahoots with.
The police are definitively in cahoots.
Gosh.
They're acting privately, and they keep saying that they're acting under a court order from the Manchester High Court. Now, that is an order. A purported order. We've always said it's a purported or an alleged order. In the past, when we've had court claims and we've been in court, whenever we've had any court order, it has always been sent by either the county court or the High Court District Registry in a franked envelope to us, basically giving the order. And sometimes them judgments are signed, sometimes they're not signed. if it's an approved judgment that's been done by, for example, the judgment against the Secretary of State for Work and Pension when I got it was a signed judgment by His Honour Judge Armitage QC, who actually signed it in black ink. Yeah.
Yeah.
So we, in this position, have not had any sight of any order or judgment from the court. What we have had is an order that purports to be from the court, sent to us by Plexus Law, who's a solicitor firm in Leeds. Okay.
Are these? Is it signed by anybody though?
No, absolutely not.
There's no signature on there.
Absolutely not.
So this is fake then?
It appears to be a fake document. We went to the High Court to question its validity in front of His Honour Judge Bird QC in November of last year, and His Honour Judge Bird QC would not give an answer. He just simply kept saying it appears to be that there is an order. And I said, well, appears to be an order is not the same as saying that your colleague, His Honour Judge Pellin QC, has made that order. So I'm asking you again, for the record, is that a genuine order? Has it been made by His Honour Judge Pellin QC? And if so, can I have an approved copy of that order from you, because I've never been served it by the court? And he simply outright refused to deal with the matter, and he simply kept saying to me that it appeared that on its face it was a valid order.
I mean, it's shocking, isn't it? You've got a court system and a police system that are working in tandem, in cahoots with each other, evicting people effectively from their homes.
Tenant of a property,
Yeah, and they're actually removing information from the land registry.
Yeah, absolutely.
I mean, recently I posted on my timeline, because we discussed this, didn't we, a fortnight or so ago, and I posted something on my timeline about land registry fraud, and everybody was amazed. They couldn't believe that property was being taken away from people, but it obviously is.
It definitely is. I mean, the restriction that we had, if you can let me just read that out to you, I've got the title deed in front of me here. The restriction that we had on there. So I said we bought the property on the 14th of December 2016. My solicitors dealt with some requisitions that were raised by HM Land Registry, who were my solicitors and conveyancers at the time. At the time, we were acting on their advice on the basis that there was an order for sale. There was an order for sale made in the county court which was void. And do you want me to talk about that and why it was void?
Yeah, why was it void?
Okay, so the order for sale from a Deputy District Judge, Olivia Skates, okay, she is basically a deputy. I don't know if you know this, but a Deputy District Judge is always a judge basically that sits part-time, okay? And they are always usually a solicitor or a lawyer, barrister, whatnot, that's got over 5 years' experience in the legal industry and of good standing. Yeah.
Yeah.
And then they can apply to be what's called a Deputy District Judge. Okay. Well, Olivia Skates, or Deputy District Judge Skates, is exactly that. She is a lawyer in the clinical negligence and medical negligence field, a very successful lawyer by all accounts. She's quite successful in getting multi-million-pound payouts for medical negligence claims. In this particular case, she was sitting as a judge on the 1st of April 2016, where she decided, and it's very, very clear from the transcript, I've received the transcript only 2 weeks back, and she actually admits that she has no experience whatsoever in dealing with property or land law. She actually says this to the barrister on the official approved transcript that came from the court. She then goes to basically take the barrister's lead, because she's obviously trusting that the barrister has more experience than she does. As she's already explained, she has no experience. Yeah. And he starts asking for all kinds of things, extra costs. He starts asking for certain wordings to be put into an order for sale. And she doesn't even know if this wording is correct or if it's a standard wording. She's asking him, are you sure that's right? It doesn't quite seem right. And he's just sort of leading her all the way through, where eventually she basically makes an order for sale. Okay.
So it sounds like the blind's leading the blind.
Absolutely.
And they'll both fall in a ditch.
Yeah, and that order for sale, in a nutshell, was void ab initio. So void ab initio, void from the beginning. because the county court actually lacked the requisite jurisdiction to make that order. That's pursuant to the Law of Property Act 1925, specifically Section 3, subsection 7.
But Pete, if you didn't know, if you hadn't been training to become a lawyer,
I wouldn't have had a clue,
you wouldn't have. How are
Absolutely
ordinary
no
people supposed to navigate their way through this minefield?
It's a minefield. It's a maze, you know. But in simple terms, the way I like to say it is, how on earth can a court grant the neighbour next door a 3,000 term? Create or vest a legal term of 3,000 years absolute to the neighbour next door on this property? I mean, it's ludicrous. She doesn't have any interest in the property. She's never paid anything for the property. She's never paid anything. She's never lent on the property and backed it by any kind of security or interest or charge. It's just absolutely ludicrous. But that is, again, the evidence in our possession. It was completely without merit, without any jurisdiction. That is why we purchased the property. So just to be absolutely clear, we took legal advice on it from very competent SRA licensed solicitors. We'd had everything looked at and done due diligence on the matter, and we decided, right, you know what, we can save this woman here. We can give her a tenancy, and we can get her back in the property so she can actually live there. Because at this point, she was a maths teacher. She'd been off work for 3 or 4 years, in and out of work because of the stress and the length of the litigation that had been ongoing and thinking. She'd paid the £17,500 after the Court of Justice, and now her employer, which was a school, and funnily enough, the council, who had actually worked in cahoots with a neighbour, was trying to get rid of her from the school. So we thought, well, do you know what, we've took this advice, we can purchase this property lawfully and legally, we'll do it all above board, and we can actually stop this fraud in its tracks and stop this lady from obtaining something that she's not actually entitled to have, you know?
Yeah.
Which was this order for sale, yeah? So that was the basis the company was set up, that was the basis the company transaction went through, and the restriction that the lawyers then put on the title was that no disposition, now that's a very fancy legal word, but disposition essentially means disposal. So no disposal of that land could be done without a conveyancer signing a certificate, basically proving that the person who was disposing of that land estate or that property had basically signed as Tuncashire Limited, so as my company, and they had to also take reasonable steps to ensure that the officer that had signed on behalf of the company actually held the stated office and was an authorised officer at the time that the document was executed. So questions now need to be raised as to how on earth HM Land Registry have bypassed that anti-fraud restriction that our lawyers put on, yeah?
Yeah.
Because there was never a sale by my company to anybody. You know, my company and no authorised officers of my company have ever signed a sale selling that property to anybody else, okay? And this week, we have been told by HM Land Registry this week, and we've had various conversations, obviously this is still live and an ongoing issue, so I'm a little bit limited on what I can tell you in relation to the stuff that's actually happening as it happens now. But HM Land Registry have you know, we've got recorded calls with them this week, basically saying that they don't know why this restriction was usurped, that they can't really give me an answer. All they keep saying to me is that it doesn't sound right. These are the customer support people on the call center when you get through, you know, and that they've raised it higher up as an investigation and a live investigation with the Chief Land Registrar's office, you know, but obviously that's not helping us because, you know, 3 days ago our tenant who was in the property was very forcefully evicted, not by any high court enforcement groups or agents or officers, but actually this time by the police, yeah?
Wow, I thought you couldn't find a policeman for love nor money these days.
Oh, well, you know, there was 12 of Derbyshire Constabulary's finest.
To remove one female, a sole female, from a property.
They were armed with tasers. The video, there's a video on Facebook which I can tag to you and to Miles after the show. I think it's had about 40-something thousand views in the last few days. It's only been online about 3 days, but you'll very clearly hear the officer that breaks into the property shout, taser, taser, officer with a taser. It's all intimidation. It's all fear tactics.
And she was there presumably on her own, and she was being faced with these 12 policemen.
She was, yeah. I mean, we had two situations at the property. So to just briefly explain, we had what's called a Section 6 notice on the garden, and the outbuildings. There's a stone shed and stone garage outbuilding which is combined, which I actually entered peacefully 2 weeks ago with a key. Because obviously, as the registered proprietor, not only does my tenant have a key, but I also have a key. And I entered into the outbuildings with a key peacefully. I then erected the Section 6 notices. A Section 6 notice is basically where you formally state that you are occupying that land. It's a legal warning and notice that you are occupying that land, and that you are opposed to anybody using force or violence or entering upon that land that hasn't got the court possession order or rights. So basically what you're saying is that you need to go to court and get an order to get us off, and that nobody, including the police, can come on, and it's a civil matter essentially.
So you put notices up on the property.
We put the notices up on the garage and the outbuildings, stone outbuildings on the shed. They were on every window on that outbuilding. They were on every door on that outbuilding. They were laminated. They were affixed by cable ties to the gate of the garden.
And you know how to do this because you've been qualifying in law.
Yeah, because I've done it before, and simply because also it's a very successful method, and it's how the anti-fracking communities across the country have occupied neighbouring fields to where gas or unconventional exploration or drilling has been taking place, by occupying land in and around that area so that they can camp and protest on neighbouring fields and neighbouring owners' fields. Fairly peacefully. So in order for that to happen is that person who actually owns that particular piece of land that they're now occupying would then have to go to court and get a possession order. Yeah. And we've been very successful, and that particular movement has been very successful in doing it. And it's always been a case that the police will not entertain going into a Section 6 cordoned area, because obviously we had people living in tents on that site as well. There were 2 tents erected in the garden, and also cable-tied laminated notices against them tents as well.
So this was in Recker's Garden, that was?
Absolutely, yeah. And that was the case for a couple of weeks, and it worked for a few days.
Did the police actually come and have a look at these notices, or did you write to them?
Yeah. The police came, and then PC Bennett actually came very forcefully, and on one particular day, it jumped over the fence in the garden, removed the stones that were against the gate to prohibit anyone from. We had basically large granite stones, if you want to call it that, against the gate to stop anyone opening the gate, basically. And he removed the stones, and he let 2 builders in. These builders were apparently employed by the fraudster John, who is now claiming to own our property. Yeah.
Right.
So they had tools and machinery on the property. We weren't aware that they had tools and machinery on the property, but they had a cement mixer. They had lawnmower, some tarpaulin. They had some aggregate, some stones, some building merchant supplies, and some turf up on the land. So instead of asking us, would we allow the builders to come onto the land and remove their property, they didn't do that. They simply got the police officer to climb over, remove the stones, allow two builders or garden maintenance people, whoever they were, to come onto the property, remove their gear. There was a bit of an issue initially, because obviously I'm heard on camera asking what the police officer thinks he's doing and who these people are that he's just decided to bring onto my land. Eventually it transpires that they were workmen or whatever that were coming to get their property off the land, and he was allegedly there just to facilitate that there was not going to be a breach of the peace, But he went way above that, and you can actually hear him on camera state that he knows he's not got any right to be on the land. He came in an unmarked police car, and he wasn't in uniform when he came either. He wasn't displaying his shoulder epaulets or other parts of the uniform.
Did he
and
give
knew
you
that-
his number? Because it seems to me these days that the police do not like to give their number out.
He did actually, yeah.
Oh, that's amazing.
He announced himself as PC Bennett with an associated number. We have since obviously had conversations with PC Bennett afterwards, where he refused point blank to look at the registered title and the official copy of the title that I tried to serve on him, letting it drop to the floor.
It's just shocking, isn't it? Well, I think really, Pete, there's a lot for people to take in tonight. We're inviting you and your colleague, Ken, to come on the show in a couple of weeks' time. And I think we can perhaps clarify lots of the issues that you've raised tonight. Obviously, this case will have moved on.
It will have moved on, yeah. We've got obviously a lot of work going on as we speak. We've got lawyers that we're actually in talks with this week that are willing to take actions against the police, both in a private prosecution fashion and also in a civil damages fashion.
Who's funding this, Pete, may I ask?
Pardon?
Who's funding these lawyers?
Well, that's to be discussed at this minute in time. So we've had the calls, and they're actually wanting to travel up to see us, which is quite unusual because usually you're told to go and see them, and they're actually down south. But they're actually wanting to travel to us, given the nature and the high profileness of what is actually happening here.
Because of course you've been in the papers, or this case has been in the papers on more than 2 occasions now.
Yeah, it has in previous matters, but obviously nothing in relation to obviously ourselves and the situation that we found ourselves in, where our property and title to our property has literally been stolen and transferred into the name of a fraudster, basically.
So when does the land registry go totally digitised? Do we know yet?
Well, it pretty much already has in some respects, because what happens now is no matter which office you send papers to, so whether you send it to Hull, Wales, Birkenhead, Nottingham, wherever, Gloucester, as soon as that office receives the papers, what happens is it is sent to like a bulk administrative centre.
Yeah.
And that administrative centre is a PO box in Gloucester. Okay.
Yeah.
That office then bulk scan every piece of paper digitally onto a system, and then once that system has that scanned on, they can then transfer that to anybody in HM Land Registry at the touch of a button, very quickly. And then what they do is they call it dematerialise. They dematerialise the either the originals or the certified copies of the originals that you've sent in. And it's very important, especially for people that aren't using lawyers. I mean, most people do use lawyers, to be fair, to purchase property and conveyances, etc. But if people aren't doing that, they may find that they send their original deeds to the land registry, and actually they won't get them back because they're automatically dematerialised, and there's no mechanism to retain them. Yeah.
Well, I mean, there are a lot of people that don't trust anything digitised, and there'll be a lot of probably worried people hearing your story. And I just would like to say thank you, Pete, for coming onto the show. And we look forward to hearing from you and Ken in the studios in a couple of weeks' time. And, there's been comments made on Facebook, and hopefully you can get round to answering them.
For sure, yeah.
All the queries.
We'll definitely check all the comments. Yeah.
Okay, well, thank you so much. And it's good night from us here in Wiltshire. Good night.
Thank you.
Thank
Good night.
you.